There are eight things that every single one of you involved in fighting for Second Amendment rights need to understand what the U.S. Supreme Court did in our favor in the Rahimi case. This is very important that you understand these 8 things. And if you're a lawyer or you're litigating these issues, guess what? You really need to know this. Luckily, I put forth this in my Harvard Journal of Law and Public Policy article, but we're going to go over it here in this video because they're so important that we get this right. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks by Hamas on Israel teach Americans about the right to bear arms. We must learn from the mistakes of others. For those of you who have bought the book, thank you very much. And to the extent you would like to continue to support me, feel free to put a review on Amazon, good, bad, or ugly. It's always nice for people to review my work, and that way I get some feedback about how I can improve and what's good and bad and ugly in terms of what I write. Okay, so speaking about what I write, as you know, I just published an article in the Harvard Journal of Law and Public Policy entitled Much Ado About Nothing, which of course is the title of a Shakespeare play, a comedy, very funny if you've ever seen the movie with Emma Thompson and Kenneth Branagh. It's a little old now, but still quite funny. Much Ado About Nothing. Kate Beckinsale's in it, by the way, so that's always a positive. Nevertheless, the title of this is Much Ado About Nothing. Rahimi reinforces Bruin and Heler. I talked about this before, but I want to focus on 8 critical things that I lay out in this article, and it's not really from me if you think about it. It's actually from the Supreme Court. These are 8 critical things you must understand that the Supreme Court said that's very, very, very good for the Second Amendment movement, and they wrote about it in the Rahimi case. And these are the sorts of things I'm going to go over that will make you the smartest person in the room, and they're the sorts of things that the anti-gun movement wants you to gloss over. They want you to ignore, but they can't. It won't work because I'm going to be here to give you the information. And again, it's not from Mark Smith. It's actually from the Supreme Court itself. I'm just making it clear that you don't miss it, because trust me, if you read the stories about these cases, they're going to try to slide it by you, but it won't work because you have the Four Boxes Diner here. All right, so let's talk about what I call in the article the 8 dogs that did not bark. Okay, you may recall from the Arthur Conan Doyle story about Sherlock Holmes, he was able to solve one mystery because the dog did not bark in the middle of the night. That told him that the criminal, the bad guy, was someone that the dog knew. It was someone close to the home. Again, the notion that the dog did not bark in the night is very important. Here are the things that did not bark in the night in the Rahimi case that we need to know about. The first thing, of course, this is very good news. The Supreme Court absolutely rejected the Joe Biden, Kamala Harris argument, the DOJ argument that that the government has the authority to disarm people simply because the government thinks that you or I are not responsible. The Supreme Court utterly rejected that. So the first thing is, simply because someone is not responsible is not a basis for taking away or their right to keep and bear arms and for disarming them. So this is what I write about in my article, quoting in part what the Supreme Court said in Rahimi about why being irresponsible is simply not enough to be disarmed. The government invited the court in Rahimi to find that Heler and Bruin established an extraordinarily broad principle or historical tradition, namely that legislatures may disarm those who are not law-abiding responsible citizens. The Supreme Court rightly and summarily rejected that attempt to find a historical tradition based on dicta in other cases rather than close historical analysis in the case before it. Chief Justice John Roberts wrote for the majority the following, quote, "We reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Responsible is a vague term. It is unclear what such a rule would entail, nor does such a line derive from our case law. In Heler and Bruin, we use the term responsible to describe the class of ordinary citizens who undoubtedly enjoyed the Second Amendment right. But those decisions did not define the term and said nothing about the status of citizens who were not responsible. The question simply was not presented." Powerful language from the U.S. Supreme Court. Again, big win for us because the anti-gunners wanted to say if they could show that we're not responsible in any respect, they could disarm us. That's not the case. As I predicted and as the Supreme Court said, the only way they can disarm you is if you are a violent danger to someone else. It may ultimately be extended to that you're a violent danger to yourself in the context of mental health and suicide issues. But for the Rahimi case, the focus was on danger to someone else, i.e. Mr. Rahimi's ex-girlfriend. And that's why they said if you have been found by a court to be a violent danger or violent threat to a third party, you can be temporarily disarmed, is what the Rahimi case said. But let's go to the second thing that you need to know about the Rahimi case that's very good for the Second Amendment. The second critical thing is to understand that the Supreme Court reaffirmed the Heler and Bruin methodology of text first, burden shifting to the government, and then forcing the government to find, if they can, a long-standing historical tradition of some sort of firearms regulation over the attempt by, for example, the Department of Justice of Kamala Harris and Joe Biden and Merrick Garland. The Supreme Court utterly rejected any suggestion that interest balancing, tiers of scrutiny, strict scrutiny, intermediate scrutiny, any kind of balancing of the good of guns and bad of guns can possibly be considered. They made it very clear that the framework of Heler and Bruin, which is text first, then historical tradition second, that framework remains the law today, and every lower court better get with it, is what the Supreme Court essentially said, the second big victory for the Second Amendment in the Rahimi case. And that gives rise to the third point, which again is making it clear repeatedly that tiers of scrutiny and interest balancing is simply not allowed in Second Amendment jurisprudence. Another big win for the Second Amendment by saying that is not allowed. Now, the fourth point the Rahimi decision said that's very good for us is they really put the lie, as we've talked about before. You've heard me say this over and over and over again, that expert testimony is simply not needed, especially historical expert testimony or expert testimony of historians is simply not needed in Second Amendment litigations. And the example I've been giving you and the arguments I've been giving you start to finish is how many experts were used in the Heller case. 0. How many testifying experts about history were used in the McDonald case? 0. How many testifying experts about history were used in the Bruin case? 0. How many testifying experts were used about the Second Amendment in the Caetano case? 0. And how many testifying experts now have been used in the Rahimi case? For example, the answer is 0. And that's because Chief Justice John Roberts and all of the justices on the Supreme Court made it clear that trying to identify a long-standing historical tradition of laws is what lawyers do. Because remember, we're not talking about, when we're talking about history here, you're not trying to establish some cultural history, some comedy history, some theater history. You don't care about the history of, let's say, period undergarments in the Victorian era. It totally doesn't matter. The only history that can possibly justify a modern-day gun control law is legal history, the historical tradition of laws. Who is the experts in finding historical laws and applying them to modern circumstances? Oh yeah, that would be lawyers, law clerks, and judges. Things that lawyers do every single day. Nevertheless, it is nice to see the Supreme Court made this crystal clear. So when you're out there litigating with experts, you're making a big mistake. You're playing into the hands of the anti-gun movement that can always draw dozens and dozens of anti-gun professors from all these schools all across America, and all these anti-gun public health schools don't play the expert game. As the Supreme Court said yet again in the Rahimi case, this is what they wrote. As I explained in the article, quote, Rahimi also relied on briefing and argument to decide the case, exemplifying for the lower courts the exercise of legal research and reasoning without the need for expert reports from historians. Indeed, the Supreme Court explicitly doubled down on Bruin's statement that the process of analogical reasoning, which is a form of discerning and developing the law, remains, as it has always been, a commonplace task for any lawyer or judge. The Supreme Court showed by example that courts can and ought to resolve matters of law through competent consultation of such sources as precedents, historical laws, commentaries on laws, law reviews, the Congressional Globe, and a handful of histories about legal topics. Powerful language there by a handsome YouTuber that you all know and love. some of you may not know and love, but you at least like my hair, so I'll call that a win. Now, the fifth thing that the Supreme Court did was they specifically said, and this is kind of interesting, on the one hand, they said that they were not going to resolve finally the debate about when the founding era is, or I should say when you focus on when historical regulations have to be around. Is it the 1791 time period during the founding when the Second Amendment was adopted, or is it 1868 when the Second Amendment was applied to the states through the adoption of the 14th Amendment? Now, I am pretty confident that ultimately this is going to be 1791. And if you actually look at what the Supreme Court did in Rahimi, if you look at their actions and not necessarily their words, because their words said we're not going to resolve it right here, right now. We don't need to because we're dealing with a federal statute. And because we're dealing with a federal statute, we only have to worry about the Second Amendment. We don't have to worry about the 14th Amendment, which deals with applying the Second Amendment to states and localities. Nevertheless, if you look at the laws they focused on, they were all founding era laws, like the surety laws, the affray laws, the going arm laws. These were all laws that were around before, not only at the time of the founding, 1791, but even before that, going back to jolly old England. They were discussed literally in the most famous legal book, arguably of all time in the Western world, Blackstone's Commentaries. That's how well established these laws, such as the surety laws, the affray laws, the going arm laws were. They actually found their way in the Blackstone's Commentaries, and that was something the Supreme Court relied upon in Rahimi. So again, while they may say we're not going to resolve the 1791 versus 1868 issue, as to what is the relevant time period for looking for historical laws. The anti-gunners wanted to be 1868 because there's a lot more anti-gun laws on the books than there were in 1791. We wanted to be 1791. But if you look at what the Supreme Court did, they basically embraced 1791 through their actions in the Rahimi case, which is good news for us. The sixth thing that the Supreme Court did that's very good for the Second Amendment movement is they took away a whole host of laws that the anti-gunners like to use. Specifically, the Supreme Court said the historical laws that are racist, that are odious, that are otherwise discriminatory against ethnic, political, or religious minorities cannot be used or relied on by the government to justify a historical tradition. This is very good because a lot of the gun control laws in the early founding and even in the 19th century were really motivated by racism. They were about disarming the slaves or disarming the blacks or disarming the freedmen, whatever it was, or disarming the Catholics because they could not be trusted. Whatever it was, these types of laws, the Supreme Court said, are no-go zones. You cannot use them if you're the government. And again, remember, this is good news for us because every single law we knock out and cannot be used is a law that the anti-gunners and the government cannot use against us to take away our rights by virtue of how they try to define and narrow the scope of the meaning of the Second Amendment. The seventh critical thing that the Supreme Court found in Rahimi that's very good for us is they made it clear that despite the fact that Mr. Rahimi was really a terror, on this record at least, an odious, violent thug, involved in 5 shootings, taking his girlfriend's head and hit it against the dashboard and then shooting at witnesses that may have seen him and so on and so on. Obviously a terrible, odious character based on this record. The Supreme Court still viewed him to be part of the people, textually, as in the right of the people to keep and bear arms shall not be infringed. The anti-gunners and the government wanted to define the people in such a way that Mr. Rahimi was excluded, but the Supreme Court very clearly viewed him as part of the people, which is consistent with the Heler definition of who is the people, which is everyone that's part of our national community. And Mr. Rahimi, being an American citizen, obviously is part of that national community. So that's very good that the anti-gunners and the government are not going to be able to sort of redefine the word people in such a narrow way to take people like Mr. Rahimi out of the definition. Because remember, if you take people out of the definition of the people, it means it's much harder for us to win Second Amendment fights because the burden never shifts to the government to force them to show a historical tradition of firearms regulations, which we always want the burden to be on the government. And the way that occurs is we show that the text is being implicated in some way by a modern-day gun control law. Now, the last and the eighth point that I want to flag, and this is the biggest point of them all, is that the Supreme Court announced no change at all to the methodology that it outlined in Bruin. The text first, the burden shifting, the historical tradition, and then when you look at the historical tradition of laws, they have to be very well-established laws, and beyond that, to figure out whether or not there's a proper fit between the historical tradition and the modern-day gun control laws, you have to look at the why those laws were enacted at the time of the founding versus why they were enacted today, and the how, meaning how they actually functioned. This is all very good. The example we've always talked about in the past is that at the time of the founding, there were fire code regulations, dealing with the amount of black powder you could store in a home in a city. And the why that was adopted in 1791 was because they were worried about conflagrations and fires burning down an entire city when the cities were made out of things like hay and wood and very flammable materials. Today, when they restrict magazines, for example, has nothing to do with worrying about fire and everything to do with about crime control. And that's why the anti-gunners today in the 21st century cannot use 18th century fire code regulations dealing with black power storage to somehow justify our modern day gun control law, because the whys don't line up. And the Supreme Court in Rahimi reaffirmed that to figure out if something is an analogous law, you have to look at the why it was enacted today, why it was enacted at the time of the founding, and how it was enforced at the time of the founding, and how it was enforced today to make sure they all lined up. Very good methodology in favor of the Second Amendment rights, and the Supreme Court in Rahimi reaffirmed that methodology yet again. All right, folks, well, I hope you enjoyed today's show about the 8 most important things you need to know about how Rahimi protects our Second Amendment rights going forward. Make sure you feel free to read my whole article in the Harvard Journal of Law and Public Policy. I put a link to it down below in the description of this video. Make sure you subscribe to this channel. We continue to try to grow this channel. And don't forget to follow me on X at 4Boxes Diner, and we will see you again here very soon, I hope, at the 4Boxes Diner.
Orders up. Table 2A.